You're sitting in your truck at midnight, staring at a stack of invoices that are 30 days past due. Your bank account is hovering near zero, your suppliers are demanding cash on delivery, and the client who owes you $5,000 for a completed job is suddenly dodging your calls. It's a sickening feeling. You held up your end of the bargain, you put in the sweat, and now you're financing their business on the back of your own broken budget. When someone owes you money and refuses to pay, the panic sets in fast. You need that cash yesterday, but if you react purely on anger, you'll destroy your own chances of getting paid. Today we're ranking the absolute worst things you can do when a client stiffs you, counting down from the most destructive moves to the smartest, most effective ways to force their hand and get your money. Coming in at number 5 on our countdown, the absolute worst mistake you can make is losing your temper and vandalizing their property or sabotaging the work you just did. Imagine you poured concrete for a driveway, they bounced the check, and now you're tempted to drive back in the middle of the night with a sledgehammer to smash it back to dirt. It feels incredibly satisfying in your head. In reality, it's financial suicide. When you do this, you cross a massive legal line. The law calls this breach of the peace. A breach of the peace is any violent or disruptive act that disturbs public order. The second you damage property, you're no longer the good guy trying to collect a legitimate debt, you're a vandal. Worse, the client can call the police and press criminal charges for destruction of property. Even if they owe you a fortune, a judge won't care about your unpaid invoice if you took the law into your own hands and acted like a criminal. You'll lose every ounce of leverage you ever had. Sliding into the number 4 slot, the second worst thing you can do is threatening the client or their family. When someone avoids your calls, it's easy to let the rage take over. You might leave a voicemail saying you're going to show up at their house and refuse to leave until they write a check, or you might send a text warning them that they're going to regret messing with your livelihood. Stop right there. This is an instant trap. The law has strict rules about how businesses can collect money, and they're tied to something called the Fair Debt Collection Practices. This is a federal framework that dictates exactly how creditors can and can't behave when trying to collect a debt. While this federal law is primarily aimed at third-party collection agencies, many states have identical laws protecting consumers from original creditors and business owners. If you threaten physical harm, or if you call their workplace 15 times a day to harass them, you're violating these rules. The client can actually sue you for harassment. And if you threaten them physically, you could face assault charges. Words spoken in anger will cost you thousands in legal fees and completely bury your original claim. Taking the number 3 position on our list of mistakes, you must absolutely avoid getting physical on the job site or trespassing when you try to reclaim your stuff. Let's say you're a mechanic and you installed a brand new transmission into a customer's truck. They skip town without paying the repair bill. You know where the truck is parked. You decide to take your spare key, drive it back to your shop, and hold it until they pay up. You think you're just repossessing your property. Legally, you're committing grand theft auto. This brings us to the concept of a mechanic's lien. A lien is a legal claim or a legal right against assets that are used as collateral to satisfy a debt. In some states, a mechanic's lien allows contractors, auto mechanics, or suppliers to place a legal hold on a property or a vehicle they improved, but you can't enforce that lien by sneaking around in the dark and stealing the vehicle back. You can't breach the peace to repossess anything. The exact requirements to get a lien vary wildly by state, and they require formal paperwork filed with the local government. If you just take the car, the client calls the cops, reports it stolen, and you're explaining to a judge why you committed a felony over an unpaid auto bill. You go down to the local courthouse, fill out the paperwork, pay a small filing fee, and the court will issue a summons. A summons is an official court document that notifies the person you're suing that they must appear in court on a specific date to answer your complaint. You've the summons formally served to the client, usually by a sheriff or a professional process server. Serving someone means delivering the legal documents to them in a legally approved manner. In small claims, you just show up with your unpaid invoices, your text messages, your certified mail receipt, and your ledgers. You tell the judge your side of the story. You don't need a law degree to navigate this system. The judge listens to the facts and makes a ruling. It's fast, it's cheap, and it forces the client to answer to a higher authority. Moving up another step, once you win your case, you get a judgment. A judgment is the official decision made by a court stating that one person owes a specific amount of money to another person. But getting the judgment is only half the battle. A piece of paper from a judge doesn't magically put cash in your bank account. You still have to enforce that judgment. This is where the law gives you incredibly powerful tools to reach into the client's pockets. You can ask the court for a bank levy. A levy is a legal seizure of property to satisfy a debt. If you know where the client does their banking, the court can order the bank to freeze the client's account and pull the money out to pay your judgment. Alternatively, you can ask the court for wage garnishment. Wage garnishment is a court order directing an employer to withhold a specific portion of a person's earnings to pay off a debt. If you win the judgment and the client has a steady job, the court will literally force their employer to send you a chunk of their paycheck every single week until your invoice is completely paid off. The tools are incredibly powerful, but you have to follow the precise legal steps to unlock them. You can't just call their boss and demand a check. You need the court's authority backing up every single move you make. Finally, arriving at the absolute best and most powerful move on the entire ladder, the ultimate weapon when a client refuses to pay is using a construction or materialman's lien, if your specific type of work qualifies. If you're a contractor, a roofer, a plumber, or a supplier who provided physical materials that permanently improved a piece of real estate, you've an incredibly massive advantage. A mechanic's lien doesn't just give you a claim against a piece of equipment or a vehicle, it gives you a legal claim against the actual land and the building itself. If the client refuses to pay for the new roof you installed, you can file a lien against their entire house. This completely ties up the property's title. A title is the official legal record of property ownership. If a property has a lien on it, the owner can't sell it, and they absolutely can't refinance it. No bank will touch a property with an active lien attached to it. It forces the wealthy property owner to the negotiating table instantly. The exact deadlines to file these liens are incredibly strict. In some states, you might only have 90 days from the last day you worked on the project to file the paperwork. If you miss that window by a single day, the right to file a lien vanishes forever. It's the ultimate nuclear option for a contractor, but you must be proactive. Everything we just talked about is exactly how the legal system handles deadbeat clients. But remember, these laws shift and change depending on where you live. The limits, the deadlines, and the specific terms vary by state, so always verify the exact rules in your area before you sign and file any paperwork. And if the amount of money you're owed is massive, it's time to get a lawyer involved to make sure every single step is executed flawlessly. Tell me in the comments, what's the absolute worst excuse a client ever gave you for skipping out on a bill? If this breakdown helped you build a better playbook for chasing down your missing cash, pass this video along to a buddy who's currently stressing over an empty bank account. And make sure you subscribe to Scribble so you always know the actual rules of the game before a deadbeat tries to play you.